like to welcome everyone back to our final CLE session of the day, which will be on tech policy and artificial intelligence, moderated by Jamil Jaffer, who is the founder and executive director of the National Security Institute here at Antonin Scalia Law School. After this panel, we'll have a 10-minute break, and then we'll go to our fireside chat. So hopefully everyone will stick around. With that, I'll kick it off to you, Jamil.
Great, Joshua, thanks for having me, and thanks for having all of us. We're thrilled to be presenting today at the Center for Intellectual Property and Innovation Policy's Fall 2021 conference. Today, as Joshua said, we'll be talking about tech policy and artificial intelligence. We've got a great group of panelists. I'm going to briefly introduce them, and then we'll jump right into questions. Going from my left to my right, we have Professor Daryl Lim from the University of Chicago in Illinois. He's the director of the Center for Intellectual Property, Information and Privacy Law there. He's also a senior scholar here at the Center for Intellectual Property and Innovation Policy. So thrilled to have you with us, Professor Lim. He's an award-winning author and observer, commentator on global trends. He regularly engages with senior government officials, and his featured publications have appeared in journals as diverse as the Stanford Technology Law Review, the Berkeley Technology Law Review, Michigan Telecom and Technology Law Review, just to name a few. So thanks again, Professor Lim, Daryl, for being with us. Second, again, going left to right on my screen, we have Andrew Baum. Major Andrew Baum is the Chief Legal Counsel for the U.S. Air Force's MIT AI Accelerator. The goal of the accelerator is to establish a state-of-the-art, end-to-end sustainable pipeline of AI technology from basic research to operational prototype. He advises on contracts, IP, fiscal law, ethics, and cutting-edge AI legal developments to the accelerator program. He's also a PhD candidate in AI, defense, law, and policy at the University of Adelaide. So Major Baum, thanks for being here with us. And last but certainly not least, on my far right, Kate Gowdry. Kate is a partner at Kilpatrick, Townsend, and Stockton, LLP, where she focuses her practice on data-driven and strategic patent prosecution. Ms. Gowdry is author of over 80 publications, sharing the results of generally applicable analyses, and her work was also pivotal in the shutting down of the USPTO's sensitive application warning system, which secretly subjected select patent applications to increased scrutiny. Ms. Gowdry's research and data focus won Lex Machina and Law 360's inaugural Data-Driven Lawyer Award in 2018. Most of her clients innovate in the artificial intelligence and computational biology arenas. So Kate, thanks for being here with us. So with that, I want to again thank the folks at Scalia Law's Center, and we're just going to jump right in. So I'll start with you, Professor Lim. WIPO has since the beginning of 2019 has been holding a series of conversations about the emergence of AI as a general purpose technology with broad application and the like. They've focused these conversations around whether the development of AI and innovations around AI require IP incentives like those that we've traditionally utilized to incentivize creative production. Do you think that the continued development and innovation in the field of AI requires use of traditional IP-based incentives, or can we have innovation without using patents and trademarks and the like?
Well, thanks for the question, Jamil. First of all, let me thank Sean, Joshua, and their team for putting this together. And of course, we wouldn't be here without Ryan Abbott's nucleus that forms the basis of our discussion all throughout these 2 days. It's great to be on the panel with Andy, Kate, and you, Jamil. I want to bring us to, in answering your question, the 3 key points that I see in the description of this panel. The focus on human-centric rules, a view of regulatory developments in different jurisdictions, and the overarching opportunities and challenges. And I think these 3 key points are helpful in thinking about this tech policy framework for AI, and in more particularly, how we should respond to as legal professionals to these challenges. So the thing to take away, I think, is business and national security needs will drive the law. Whatever niceties we might want to talk about with respect to the specifics, these are, at the end of the day, the 2 overarching tectonic forces. So what do I mean by business needs, and where are we on that? Well, the USPTO put out a report in 2020. It's been mentioned a number of times, over 200 responses. And the key point there is most people were comfortable with the state of IP protection for AI. It's good enough for current purposes. Laura Sheridan told us this morning that Google is happy with it. They noticed that overall patenting for AI applications increased from 9% to 16%. This morning, we also heard from the pharma group. They were generally okay with it. And how often do you hear pharma and tech come together in agreement? So that's significant. Dennis Crouch told us that this issue of AI inventorship may be a sideshow. He talked about how trade secret, trademark, and copyright regimes recognize a corporate owner, and really there is a ready-made, purpose-made framework for thinking about that. So when we think about the problems with AI, they are identified in the particularities of patentable subject matter, whether something is non-obvious disclosure issues. And these are real challenges, which I think we'll have to get around, but there are analogs that we can look at with sufficiency of disclosure. For example, the pharma industry has had to deal with that. So it's important to realize that it may well be a concern, but perhaps not as much in the real world, that there are no safe options for protecting intellectual property. And that's important because we want to make sure we don't fall into the trap of being increasingly precise while also focusing on something that's increasingly irrelevant. Instead, I think we should be asking questions of increasing relevance, of increasing empirical rigor, and how do you do that? Real world data, that means real people, real solutions, and hence I think the value of today's conference. And I'll pause there. And just note that when we talk about national security, we are really talking today from the United States perspective about the US-China relationship and the rivalry between the two. Because those, as the report told us, the National Security Commission's report told us, is going to also shape how we view artificial intelligence. And I know we'll be coming back to that. I want to give the rest of folks on the panel a chance to speak, so I'll pause there for the moment.
Great, Daryl, thanks for that. And by the way, before I go to the next question and come to you, Kate, I want to remind folks that you had the opportunity to earn CLE here today. In order to do that, you'll need to enter the CLE code for this session. That code is DATA, D-A-T-A, Delta Alpha Tango Alpha. Again, that code for CLE is Data Delta Alpha Tango Alpha. So Kate, we heard Daryl tell us that things are going to drive. Some of these questions are going to be business decisions, national security decisions. I mean, we heard that the Googles of the world and pharma are all happy with the state of IP when it comes to AI. But you do work today in this very field, right? You work on data-driven patent prosecution. How do you think about the value of patents in this field? Is there an appropriate use for patents? Are there limits on the value of AI-related patents for innovation purposes? And if so, are there particular places where we might draw the line in that space?
Okay, so first of all, like in the field of AI and patents, I think we've had distinctions before, but there's two big categories, right? There's innovations pertaining to AI, like maybe a new type of neural net or a new use for an existing neural net. And then there's the separate category that has to do with inventions that were created in part or fully based from an artificial intelligence code, right? So in the first category, which I think is what you're talking about, like is the patent system sufficient and well suited for that? I think right now it's generally tracking a lot of software. So in the software areas, there's some types of technology, business methods, and for some reason bioinformatics also tracks this, where it's a hard road. It's hard to get things through there. They have examiners that have lower allowance rates. They face a lot of patent eligibility rejections in the US, that is. Bioinformatics isn't as hard, right, in Europe. But for the most part, then all of the rest of the AI that's going into the 2100 Technology Center, and the art units that pertain more to regular software or artificial intelligence, that generally tracks just normal software. And so right now, we're not seeing a lot of special concerns, at least from a practical standpoint. And this morning, there was a lot of discussion about what might happen later, right? As things start to evolve and maybe the laws change, maybe we want more about training data or not, right? And so one thing that I think is the biggest question now is thinking about the future, because you can get your patent issued. In most cases, the allowance rate's pretty good. But then if the law changes in 8 years and all of a sudden eligibility is different, or obviousness is different, or disclosure is different. That is something that I think that some attorneys are thinking about very carefully, thinking about how this is a very fluid area. And those are the harder considerations to evaluate.
So, Kate, in that regard, traditionally, when we have changes in the law applicable to patents, as I understand it, right, those changes will apply to existing patents. And so, if there's a change in the law around obviousness, right, that'll apply to patents that were previously granted and may modify those or requires patents to be rejected, or whatever the right term art is. Do you see the same thing? Is that correct? Is that a correct understanding of how it works? And second, if so, is that how we see it playing out in the AI domain? And if so, will that create any unique challenges in this space?
Well, a lot of times the reason why the law changes is because of case law, and then the case law is always rooted in other cases, right? And so even though the case is new, the way that the decision is written, it's supposed to not be new. It's like, you guys should have known this, right? Patent office, you should have known what you were doing, and it's too bad you didn't. But now all of the patent owners, face the consequence of having to deal with this new law. And so, yes, in those situations, it can be a retroactive impact, and you can have a lot of invalidations. Now, if you have a new congressional law, they will try not to do that. Right. It's a different story.
And so, but is there a unique problem of this retroactivity that comes out of case law in the AI domain in particular, or does it apply? Do you think it sort of applies the same way it would apply in the traditional patent context?
I think what's unique now is that we really have very few cases dealing with AI. And so we will be getting those soon, right? The patent filings are skyrocketing in this space, but we don't know how the eligibility standards and the obviousness standards and the disclosure standards are going to apply. And so, in 5-10 years, as these are getting more and more litigated, and honestly, as the judges are getting smarter about it, because people will just be more familiar with AI, they'll know what it is. And then I think things will, it will have a different kind of impact only because it's kind of the birth of it. Yeah.
So Major Brown, let's talk about the government sort of approach to this. So you're sort of at that nexus between the government, sitting in the government as a military officer, but you're serving in an academic or an academic institution, and at sort of this convergence of government, academia, and industry, trying to develop some of these new things at the accelerator. Talk about the government's view of IP in the AI domain. Does it help stoke innovation in the government's view? And if so, how does the government think about its use rights when it comes to AI? Because this is always a hot topic when innovative companies, startups, or contract with the government. This question of how much, and if the government's put money in particular, right? How much IP does the government take, and what rights does it assert, and what rights does it leave to the patent holders or the IP holders? So, Major Brown, thoughts on that in this particular AI domain?
Yeah, thank you. It's first of all, it's a pleasure to be here. There's a lot to unpack there. There's many different angles. So I'll do my best to kind of touch on a few, and I think that we'll hit on some more as a panel kind of going forward. But from I'll say, the caveat to me presenting the government perspective is what I think is probably best for everybody, myself specifically, is providing my perspective.
Your views, right.
And so the standard government disclaimer. So
this is not the U.S. government's position.
Yes, exactly. So hold it against me, not against the Air Force or MIT for that matter, or any other entity in the
anybody that might employ you. It's not their views, it's your own views. Got it.
Yeah, that's again probably best for everybody. But so with that context, I think there's a lot to kind of unpack. So part of the really interesting way, I think I'll start it this way, is I'm able to present my personal opinions on this, which is unique. Being a military officer, I'm able to come here and speak my personal opinions, which I think that kind of gets into that philosophical difference that Professor Lim mentioned between China and the United States, where I wouldn't be able to do so. And that really kind of permeates throughout the discussion of AI just generally, and AI within the nexus of IP. So it's it really kind of underscores this country's values and their philosophy, where there's a freedom to share ideas or not share ideas, and that's really kind of the root of what IP is from the government perspective. So kind of really taking it back, and most people here probably know, but when we're talking about the federal government, it's always good to talk about the source document. That's the Constitution, and so that's where we get patents from Article 1, and so that really kind of states the government policy. Or we actually believe, the founding fathers believe that granting authors and inventors exclusive rights, so essentially a monopoly to their writings and inventions, promotes the progress of science, and we still believe that. And so when we're relying on this theory that this prospect for financial gain incentivizes innovation, we're banking on that to allow us to keep our technological edge. And so when we speak of AI in terms of national security effect, the impact, well, I think in many ways, an AI system, whether it makes it onto a DoD system or not, is still going to be a national security concern. Right. It just the capabilities and impact that it has, just the ubiquitousness of AI in the coming years it's already a national security issue. It's going to be much more pronounced as a national security issue. That's what the National Security Commission on AI really foot stomped was. This is a big deal, and the federal government certainly is taking it seriously. I'm seeing it. I've been in this space for several years now, and each year it becomes more and more clear that we're starting to click. And that's really the impetus for the position that I'm in right now, working with MIT, is working with academia, with really some of the best data scientists in the world, that the Air Force is working in a collaborative effort with MIT. It's under a cooperative agreement, and also with MIT Lincoln Laboratory, in order to create advancements, state-of-the-art advancements in an end-to-end pipeline for AI systems. And so the reason why we're doing it at that level is kind of twofold. One is we want to be very transparent, and there's nothing more transparent than publicly available information on what it is that we're doing as you get with fundamental research. But also the government needs academia. It needs industry. This is not a whole of government problem. This is a whole of country problem. And so we do, and probably more so, we need our allies as well. And so big issues, obviously, kind of bring it back into IP. The way that the Air Force is approaching it in its collaboration with MIT is there are certain things that we believe the IP incentives are not going to do in AI right now. We're seeing that in the way that commercial incentives for developing AI. Well, you're getting a lot of R&D, private R&D, going into search engines or going into ad placement, things like that aren't necessarily
even AI in those contexts.
Exactly, AI in those, because there's just not. It's AI development is challenging, and it's expensive, very expensive to do, and there might not be the return on investment. Well, the federal government needs more than just advertising and search engines. Those are great, but we need more than that. And so what we're going to do is we're working with MIT and other academic institutions to do that basic and advanced research, and establish hopefully patents. We'll get to kind of challenges that we have on that later, and also open data. And so because we think that if we do the heavy lifting first, that makes the return on investment a lot more attainable for industry once we transfer that over. And so IP is absolutely a tool that we're using both in creation and in our use. And I think I'll kind of yield the floor to get back to other panelists, but I'll come back to that more directly in kind of the next iteration.
So Kate, Andrew made the point here at the end about the point that you made earlier about sort of AI innovation itself, innovation that is basic to AI, but then there's the innovation that comes out of AI, generated by AI, right? And so how should we think about, AI created inventions, that latter category? So you talked about the first category. On that second category, what's the right framework for us to be applying when we think about innovations that are created by AI-based systems? And is there a different framework that ought to be applied in that context than the context of sort of traditional human-created innovation around AI?
Right. So this is a very popular topic right now. Again, Brian Abbott's cases with Davos is raising this point, right? It's forcing people to think about it. And everyone is, all the patent offices are, right? They're taking it very seriously. And I think it's kind of forward-looking. One is what can we do right now in our existing system? And two is what kind of system do we want? And so traditionally, why do we have the IP at all? Well, it's to motivate people to be able to research and sell things and disclose things, right? So those are the three main motivations that we want to give.
Right.
So where do we want to place those incentives, right? So the patent system is pretty good. You have all the details there about how to make and use the technology. But if you have AI-generated inventions that can come out really, really, really quickly, that would be the fear, right? Because one company then, that's one fear, right? Could one company then just file a million patent applications because they've finally figured out they've cracked AI, right? So that's something to think about. We're not there yet, and I think a lot of people are trying to think about the system now, but also to be prepared. We might have to pivot at some point depending on what we see. Right now, I think the main considerations for this type of technology would be trade secret versus patents. Of course, you have copyright, but copyright is more narrow, and so most of the time if a company, let's say, has an invention sitting in front of them where they're not sure, do they have a human inventor? Is it something that they can patent or not? Even maybe a 101 issue. And then the fallback is trade secret. And so do we want to encourage one versus the other? And then, should we develop some new type of right at all? Entirely? That's complicated, right? The sky's the limit, but I think a lot of the time, my guess is that if you were trying to generate a new type of right, and I bet Daryl has thought about this a lot more, is that you come pretty close to, what the patent system is already. And we have seen, some efforts to, in Europe, they tried to give protection to databases and stuff like this, but my understanding is that's pretty narrow and limited. And so the most powerful right where you're really encouraging people to go this route and disclose everything, I think right now is in patents, although I would be curious to hear other people's opinion on that.
May I add to that, Jamil?
I was actually going to come to you. Yeah. What about that?
Since Kate called me out on it.
There you go.
Well, I agree with Kate. I think patent seems to be the default, and there are ways around it. You could see the owner of the AI deemed to be the owner of the invention. You keep things human-centric, the first point that I mentioned, while ensuring the innovation created through the AI is still protected. Or you find a human somewhere in the chain. And I think this was something that came out in earlier discussions. There's somebody that can be the inventor, and then you have the AI-generated invention being patented in the human's name. The USPTO, when it rejected the Davos invention, noted that the use of the machine as a tool by natural persons does not generally preclude a natural person from qualifying as an inventor or joint inventor. And Beethoven's 10th Symphony, by the way, was never written by Beethoven. It was written by a group very recently. AI scientists, musicologists, they came together and they had to decipher the sketches to develop a longer, more complicated musical structure. They had to harmonize it, they had to orchestrate it. But at the end of the day, the AI scientist who wrote the article, I think it was for the New York Times, said AI was a tool. It was not possible to have done it without the expertise of historians and musicians. And there was a whole lot of work and creative thinking. I'm sure somewhere in the chain you can find someone, or more likely a group of people you can hang that authorship or inventorship to. The third option is you could define the ownership or authorship, inventorship in the employment, licensing, or purchase agreement. In other words, you splinter it You specify who owns the data, who owns the information, who owns the results. I mean, we have had contract law for the longest amount of time. And the one way to future-proof these types of things is to try to contract it. Right. So IBM, for example, could retain all the rights in the data set, but license the pharma companies the rights, and the pharma company will have the rights to any new drug compounds that's produced out of the algorithm. And of course, then you have the chance in the contract to spell out liabilities and the results obtained through AI systems, both now and in the future. So there are alternatives. Kate mentioned trade secrets. Certainly that's true too. Data exclusivity for pharma data, that's there. The database protect directive in the EU has generally been seen as a negative example of how sui generis rights don't work. So I think it's also a cautionary tale for those of us who are pushing to create a new type of right or a new type of tweak to a system that business and countries generally feel that it's workable, we can adjust, but other than that, if it ain't broke, don't fix it.
Right. So I want to follow up on that, but before I do, I want to mention to the audience, there will be time for questions from you in the audience coming up here in about 15, 20 minutes. So please put your questions in the Q&A function in the webinar, and we'll get to them here in just a little bit. So Daryl, I want to follow up on what you just said. You mentioned that we need to think about, who the inventor is, and there might be a variety of people you could assign. If it's human-centric, you might assign the invention to a variety of people. But is there a right answer here? Should it be the inventor of the AI system, right? Should it be the people interacting with the AI system, providing the data in, or should it be done by contract? I mean, do you have a view on that question, or is it just sort of the framework and the nations and the like need to figure this out on their own?
Well, if you look at the UK Court of Appeals decision, the majority made a point of noting that this was an object, I'm quoting the Court of Appeals now, an object lesson in the risks of advocacy being distracted by glamour. There was more than a hint that if the inventor in this case, well, inventor, I should say, since the inventor itself was contested, Dr. Thaler was not such an obsessive and instead called the AI Darbus as the inventor and named himself, then none of this would have happened. So would a patent office reject an invention if it had named a human being? Probably not. I mean, in South Africa and in Australia, they've got different patent provisions. And South Africa in particular has its own industrial policy reasons to want to, shall we say, be more relevant in the IP world. But Australia, I mean, Section 119 of the US Patent Act provides a cautionary tale, because would you be able to claim priority application in Australia and South Africa if you had filed there first and had put the AI as the inventor? I think that's a risk that I think attorneys might be wary of putting their clients into. At least not before they have paid their malpractice insurance.
Right. So Andrew, one of the things that one of the points Daryl just made was that the laws are significantly different in a variety of jurisdictions, right? The way we think about these questions, who the inventor is, how it's obtained, the rights they have in it, and yet the questions of priority in different jurisdictions. So who should decide these questions of patentability when it comes to the AI arena? Should it be nation states, sort of our traditional way? We have now supranational bodies that help bring together some of these questions, and WIPO and the like. Something else? I mean, and what impact would it have if we stuck with the sort of nation state regime or went to a supranational regime, right? Would it have an impact on innovation space? And if so, what do you imagine that to be?
Yeah, I think it will. And this kind of goes into my PhD research, where most of what I did was talk to a lot of CEOs at commercial AI firms and got their perspectives on really trying to answer the question why they want to work with the DoD or why don't they want to work with the DoD. And it's contracts. That's basically the reason for both. It's one, contracts provide revenue. That's great, but also contracts with the DoD are challenging, and so that's kind of the negative. But what was a theme throughout my research was this: AI knows no national borders. It is an international technology. And so IP rights in one country, it's going to be a problem in another. And so with that, there is a drive to commercialize beyond, obviously in the national security space, that raises some additional issues with ITAR and export controls and who we do business with. And so again, all these kind of mundane everyday things, it's very easy to tie back to national security, but who ultimately decides? There's different philosophies on what the goal is for intellectual property, what might work in one is like in the EU, particularly with privacy, data and privacy, they have a completely different set of laws.
Right.
So anything dealing with data, they're probably too strict on data for U.S. purposes. And so there's a lot of considerations. I know, regardless of kind of what happens, it's my hope that the U.S. is very much involved in coming up with that idea and at least making it clear to U.S. business and our allies that IP in dealing with artificial intelligence is something that we take seriously. One for protecting IP rights. That's something that the government is. We protect rights in a way that most customers aren't going to. We usually fund it with non-dilutive funds. We don't take equity, and so there's. On the other hand, we still ultimately need to be good stewards of taxpayer money and be able to get the mission done. And so there's a lot of balancing that goes on. It gets very complex. So all that to say, I'm completely dodging the question and not saying who I think should be making those standards, other than we should be very much involved in this conversation. But it's incredibly complex because there's so many different considerations that impact the society, our economy, and our national security.
Yeah. Well, Kate, I want to bring you into this conversation. I don't know if you have any thoughts on what Andrew just said, and whether you're willing to actually take a position on who ought to decide. But as you're thinking about that, I'm interested to also know sort of your views on sort of the point that was made earlier about this competition that we have with China, right? It's clear that a lot of the way the U.S. Is thinking about our challenges in the AI arena are viewed, as Daryl said, through the lens of the China competition. And so what are the national security implications if we choose one of these regimes, right? What impact does it have on the competition with China? And does the relative lack of rules in the space today, particularly here in the U.S., undermine our ability to compete with China, given that they're sort of moving out pretty quickly in this space?
All right, so I'll try to remember all those questions. Let me know if I forgot one.
I'll jump in.
The initial one was, what did I think about Andrew's response, right? In terms of whether or not we should have a global system that applies to AI. Now, what's the advantage of that? Well, the advantage of that is if I'm the US and I want to help my companies, I want to help them get protection all over the world. I also want to think about the companies that they're kind of excluding, right? So the generics, so to speak, or anybody who might benefit from this, and do I want to penalize them in my country versus in the other areas of the world? Now, one possibility, if you have disparate rules, is one potential consequence is businesses might shift, right? And they might say, okay, well, I can protect this in China, or I can protect this in Australia, and I can't protect it here, so I'm going to go there. But think about how that works for patents, because patents require you to disclose things. And so even if I can get the patent in Australia, if I'm disclosing it to all of my competitors in every other country, I don't know that it gives you that kind of jurisdictional leaning that you might think, at first blush. Okay, so that was question one. And question two was this idea between the US and China, and how our rules could impact a competitive advantage, right?
Right.
So then in that regard, there's a lot to think about there. I feel like one is just, what's the innovation that's happening in both of these areas? And you might think if you have disparate rules, like going back, one might benefit more than the other. China, I understand, I don't know the specifics of this, but I understand that there were a lot of, there was a lot of encouragement. There's a lot of encouragement to file patent applications there, right? And so you are encouraging people to innovate, you're encouraging people to file, and that can help them if they're having more innovations than they were before. If we're saying here, we're not encouraging you to innovate. In fact, we're encouraging you to force a human into the pipeline, and then you're potentially not going to have as much investment over here as you would over there. Now, I would like to bring up one of the regulations that I'm not an expert in, but I've heard about, and that is the regulation of human genetic resources over in China. Maybe Daryl or Andrew knows more about this than me, but this I find to be like an interesting thought process. So this says that if you have human material, right, if you have genes or samples or anything else that was collected in China, then as a foreign entity, you need to have a Chinese entity that's a joint owner on any IP, right? So what does that mean for me if I want to get patent protection over in China, or maybe I want to have some sort of technology that's based on, let's say it's even, like I'm trying to think of a parallel that might apply to the AI space. If you had that same type of regulation, and you couldn't have images, you couldn't train your autonomous vehicle with images in China unless, you were willing to take any IP and give kind of co-ownership. Like, how as a global company are you going to deal with that, right? And in the medical space, you might say, well, I want to be able to find drugs that work, across different environments, right? They have different kinds of things in their air potentially, right? But in order to patent any of that, and then I would need to partner with somebody over there, right? So it's this weird, like, cross-jurisdictional thing where the laws of another country can really impact anything that I'm trying to do, so long as I'm a global corporation here. And then, the competition, I think, is, I guess, not hand in hand, but it's almost, a side consideration where it might go either way.
Yeah. So Daryl, what about that? I mean, this is, I think, Kate's raised another important point here, which is, how do we think about these IP protections, that require, they're sort of in some ways extortive, right? Where China's saying, look, I mean, this is something we've seen in other contexts before, right? Which is, you want to do business here, you got to do it with a joint venture with one of our companies. Now it's, you want patent protection or IP protection, you've got to do it jointly with one of our constituent entities, so. Do we worry as a general matter in the IP arena that's being used in this extortive way? And if so, is there a special or particularly problematic resonance, maybe in the national security context, when it comes to AI?
All right. I think the short answer is yes, this is a problem. That was the problem that the trade war between China and the US had attempted to solve. More specifically, phase one of the trade deal was trying to solve this issue of forced tech transfer.
Right.
Many American businesses and other European businesses had for the longest time just seen this as the cost of doing business in China. You can't afford to miss out on a country that's twice the size of the United States and 4 times its population and fast rising to becoming the dominant superpower. So what do you do then? Well, one way to do it is to have a global consensus. That's the point that Andy was making, that this is a global issue. We need to have global rules. And Brian Abbott, I think quite rightly said that WIPO is seized on the issue. But I think it realizes, the World IP Organization, that it's difficult to get the ducks in line. It's worthwhile getting the stakeholders thinking about these questions, but really, if you think about the history of international intellectual property protection, the landmark deal that people still go back to is the TRIPS agreement of 1995, the really only one with any teeth to it, because it's linked to the WTO trade agreement.
Right.
When was that? 1995. How long has IP been around? Much longer than that. We are at the dawn of a global consciousness of artificial intelligence. And artificial intelligence perhaps more than any other area of IP subject matter that we have had to consider so far, is deeply infused with political ideology. Now, that's important because if you think about where we were in 1995, the group of people that came together to say these are the rules of the rest of the world. These were Western liberal democracies.
Right.
Today, the world is quite different, and you've got national security folks in this room. You understand that these types of political ideological differences do have profound impact on how the rules look like and whether or not we can even have agreed rules at all. Which is why, in a sense, the AI rivalry has been analogized to the space race. So this is the Sputnik moment. At least we hope so. In the United States, we see China taking off.
Well,
what are we going to do?
We hope it's not the Sputnik moment, right? We hope we get there ahead of them. But if we're going to lose, we need to accelerate past them.
Well, yes. You also need a JFK, I suppose, and you need a national space program, which is what I think we are trying to do. Now, how can we do this? We have, in theory, many multilateral tools and plurilateral tools at our disposal. We have the CPTPP, which itself has cross-border data flows. It has localization requirements, it has privacy. It has the architecture for the global framework for AI. But while the United States was one of the key architects of the CPTPP, then known as the TPP, it walked away because of domestic considerations. Even then, candidate Clinton, who was Secretary Clinton at that point in time, said, no, I can't do this. I'm disavowing it. So I think there has to be that political will. Foreign policy starts at home. That's the first point. The second point is, I think it's important to go beyond the rhetoric in China. And China is ahead. China has more patents. I think that's true to some extent, but has China won the AI fight? I think that was maybe have been the underlying question that you were asking. So I'll give you some statistics to work with. Its research papers vaulted from 4% to 28% in 20 years. And as Kate rightly pointed out, it files probably more AI-related patents than any other country in the world. But so what? Say some commentators, because research in AI doesn't prove a durable advantage. AI is open science. It's not like pharma. It's not even like mobile telephony. And the key to AI success is data and domain-specific knowledge. Now, right now, China has a large population. It takes up its products very quickly, but it's mostly weak AI. Now, there really has not been clear policies or priorities, and most of it is done at the university level. So unlike in the United States, where most of the AI is driven by the private sector, there is no similar success with the Bayh-Dole Act, for example, where they transfer the know-how into and commercialize it for the rest of the population.
Yeah.
Also, if you have bought any stocks recently in China, your heart would have missed a beat because the prices dropped precipitously. Why? Because of what they call this common prosperity initiative. So would you want to invest in businesses like Alibaba and so on that have been much the drivers of AI policies and progress in the United States? Maybe not so. Also with chips, China is at least 2 generations behind the United States when it comes to chips. And so far they can make do, but if they really want to catch up with where we are going with 6G and everything else, they would need to develop their own chips unless there's a thawing in relationships. So China has potential, but it also has its issues. The United States similarly also has its issues because until now, our biggest drivers of this AI advancement have been companies like Google, IBM, and Facebook. But flip open the New York Times on any given day this year, and you have seen these are also the companies that are running afoul of antitrust laws, running afoul, whether you are a Democrat or whether you're a Republican, you can agree that companies like Facebook are not good. I think the danger there is one of substitution bias. In hobbling your most disfavored tech company, you may also be pulling down the whole country's competitiveness with respect to AI because these are the engines that are keeping this country ahead of the rest of the pack. So I think it's important that we take a very nuanced approach to regulation of these tech companies and make sure that you don't kill the patient as you try to treat the disease.
Well, it's a great point. And in fact, we've actually been running a series here at the law school about this intersection between antitrust law and national security and discussing exactly these questions about whether, sort of you're killing your effort to go after the golden goose is sort of taking down the larger farm. But I want to come back to something you talked about, which is this issue of data, right? And whether the collection and utilization of the data that's so at the heart of having capable AI systems, right? Training the AI system on a large amount and a vast quantity of data. It seems that authoritarian regimes have a better capability, right? They can sort of force their populations and their companies to cough up the data they need. They can provide it to the nation for the training of AI models and the like. They can, as we see the Chinese doing here in the United States, steal vast amounts of data from us with a fairly low cost to them. We've seen all the hacks that have happened in the United States, whether it's OPM for national security purposes or the vast majority of Marriott, Anthem, you name it, that took place that were the Chinese government, now the US government has disclosed, right? Do we worry that the ability of authoritarian regimes to gather data from their own people and steal it from their adversaries empowers them in a way that democracies might not be empowered when it comes to training their AI models? Daryl, that's for you.
Well, so far we have seen that while democracy has many flaws, it probably is still the best form of government that we've managed to come up with. What's the alternative? You can have a Julius Caesar moment. You go, you take over the Senate, and you become the autocratic ruler. So far, the United States has not moved in that direction. I think it's a very big reason why the world regards and respects the United States as a benign power, and why, for many reasons, it's still the only superpower. And I don't think that China will be able to do that unless it relooks very hard at how it's approaching its policies on the South China Sea, for example, and many other areas.
Yeah.
So how do we, in a rules-based system, still try to maintain our advantage, if not increase the lead? Well, we make use of what we have, which are the laws. Now, one law in particular has been an issue that many countries have been seized with, including the United States. But I would suggest to you that the answer to the United States conundrum on that data generation issue may be found on the other side of the world in a tiny place called Singapore. Now, a couple of things that are interesting about Singapore that's worth the United States' attention. One is its global rankings has always been in the first, second, or third, very high, or the top 10, depending on the index that you look at, but very high. Small, open economy, it's perpetually concerned about flight risks in investment and talent.
Right.
So you need to have a regime that makes sense for the long term. And its copyright rules are actually very similar to the United States. And why is that important? Because the text and data mining provision that it had enacted into law recently specifically carves out the ability to, for commercial purposes, extract and study the data. Now, in the United States, you have things like the fair use doctrine, but just look at Google v. Oracle and how later courts have interpreted it. They have basically tried to cabin it. Even the Supreme Court in that case went out their way to say that it's very, very fact specific. So it doesn't really give companies a whole lot of comfort in determining whether or not they can go out and generate the data sets that they need in order to really fuel AI innovation. And there are many aspects of the legislation I think that's worth looking at, but the fact that it can be used for commercial use, the fact that it negates contractual provisions that limit the use of text and data mining, but only if you do it in Singapore and only if you acquire it legally, means that it gives a country like Singapore with a safe harbor a tremendous advantage over regimes where it's otherwise less certain, like the United States, or otherwise you deal with countries like Russia and China, and you do so at your own risk.
Yeah. Yeah, I do see there are questions in the chat, so I do want to encourage folks from the audience. If you go and put your questions in there, we'll get to them here right after I have one quick question for Andrew, and then I'll turn to the questions in the chat. So Andrew, I'm interested in your thoughts, and again, you speak for yourself and not for the U.S. government or anybody else that employs you or you might be associated with. But I want to understand, sort of we talk about Chinese IP theft, right? We talk about these sort of extortative policies in China, we know that AI is not the only critical technology in play in this competition with China. And so as we think about intellectual property, should our view on Chinese behavior change the way we think about IP in the AI context, or at least affect it when we talk about the global context? And if it does or doesn't, either way, how might our thinking on AI and IP change our thinking about IP in the other critical technology context, whether that's quantum or the like, or does it have no effect?
So I think I'm going to go back to something I mentioned before. There are philosophical differences between the United States and China, and Daryl hit on very, very well put, where he said that, look, there's authoritarian regimes, and they have an advantage in that they have they have a tremendous amount of just people as a resource, but they also just collect. They just collect a ton of data. They're building smart cities with sensors everywhere. They're just ingesting data, and that's one thing that I am concerned about. Is while I think that the number of patents I am not concerned about, because they came out with policy that we want to have the most patents. Okay, well then it's all quantitative. It's not qualitative, and so that's less concerning to me than the fact that they understand the importance of data, and that's something that I think we're just starting to comprehend. And so when they collect so much data, they're doing so very purposefully, and they are spending the time to actually make not only collect data, but collect machine learning readable data, which we spend 80% of our end-to-end pipeline budget on an AI system just getting data wrangling and cleaning it and putting it in tabular form. We're at the AI Accelerator at MIT. We're working, focusing a lot on bringing that ratio down. But the most exquisite algorithm in the world is useless without the right data. And so we need to manage that. And I think open data, so fair use agreements to really. And this is something that the government can do, something that we are doing with our public challenges, where we're creating massive data sets that are released to the public and saying, hey, here's some interesting problems. Why don't you go try this out, and pushing it out. That I think is going to start, whether it's a prize or just bragging rights or whatever. I think that is a way that we could use data to stimulate our advancements in AI. But that's one advantage that I think China has right now over us, is their appreciation for the importance of data and what goes into most people understand that the data is a big deal when you're doing machine learning, but they might not appreciate just how important it is to get the right kind of data and to have it machine learning readable. And so China knows that, and they spend, they pay people, essentially slave labor to actually go and clean data, and it's just very laborious and tedious. There's ways to fix that we're working on, but that's one big red flag I think that we need to come around to. And the National Security Commission on AI definitely mentioned that is a big deal. We need to get serious about that. But I think there's parallels to kind of go back to your question with other technologies, and the role of the government in making sure that the incentives are aligned to ensure that we get that we do advance in 5G or quantum computing. And again, those, it's the reason why I want to do that is really the impact on what it could do for our advancements in ML. But so that I think they're all related. But I think other areas in the world, so the EU does a lot in terms of kind of this theory of public procurement for innovation to really kind of kickstart innovation that would otherwise be difficult to arrive organically. I think you're seeing that in all of these advanced emerging technologies that have certainly national security interest, but also commercial interest once the technology matures. So hypersonics and space launch and these big hard techs that are going to be hopefully very, very prominent in the next decades. But it comes down to what's the big one that we're talking about. It's really deep learning and machine learning. And so while I think those other technologies, we need to also think through some of the IP issues and how do we incentivize innovation in this country. I do think it comes back down to AI being probably the most critical deep tech that we're working with right now.
Yeah, interesting. Well, I'm going to go to the audience for questions. And so for those in the audience who haven't asked a question yet, please jump in here and ask away. But I'll start with Lester Fettig. So Lester asked whether the panel can comment on this question. There are more Chinese agents, in his view, sitting at USPTO headquarters in Alexandria than there are lawyers. In his view, the whole patent and trademark system is a hunting ground for the Chinese government, with all the filings going straight to Beijing. This goes to Kate's point about disclosure and the fact that that's part of our regime, right? So he points to you, Andrew, and says that this, and is wondering why the prudent advice is to rely only on sort of trade. He says trade practice, but I think he means what's the word I'm looking for? Kate, help me out here. Trade secrets protection, right? Versus sort of the normal disclosure approach, which undermines U.S. values, incentives, and decentralized democracy. So the question he's asking at the end of the longer statement, right? I think the point that Lester's making is, are we losing the battle in part because our system incentivizes disclosure? We've always thought as a positive part, you get the monopoly for a temporary period of time in order for the disclosure to create more innovation. Is that undermining our competition, the global competition in China? We'll start with you, Andrew.
Sure. Yeah, it's a fascinating question because there's so much. It's a balancing act because there's trade-offs on either whichever direction you go, and so are we concerned about for instance where I'm working on fundamental research becoming public? Well, no. Again, that kind of goes to not so much of how the innovation that we're producing going to adversaries. It's kind of beyond that. It's transparency, because there needs to be trust in the system. There needs to be again, it goes to we're operating under a different philosophy where we should not equivocate on ethics, and we must not equivocate on ethics. We must earn the trust of the public, and this is a sensitive area, and I'm sure most people probably heard of kind of what happened with Project Maven and Google a few years back. It's not we can't take for granted that U.S. business wants to work with the DoD and the intelligence community, and so there's a purpose behind that. Is there a trade-off? Yeah, I think there is. I don't think that should surprise anybody. But ultimately, patents allow us to, sure, they're public, but that's the great thing. And so speaking as from the perspective of the Air Force, in kind of putting on the customer hat, we're the biggest customer. Well, the DoD is the biggest customer in the world, and we operate with a kind of a somewhat parallel, somewhat just foreign IP framework, and so we think quite a bit about what impact our data rights clauses have on innovation in national security space. Well, if what ends up happening is, particularly for government-funded research, which is what we're doing, if it's patent, well, that's great. We have a worldwide fully paid up license to practice that patent, that invention. When we do that, if it's a trade secret, well, no one else gets to see it. We end up having to negotiate clauses that the way that most standard DoD contracts work. It's kind of if it's kind of who funded what when is really the threshold question on whether what type of use cases, what type of use rights we have. And if we want more than what we would get, so if a company comes with a trade secret, that special secret sauce that you hear AI companies talk about a lot, because a lot of them aren't patenting their inventions because it's just it's confusing, as the National Security Commission on AI said. You end up getting trade secrets, and that's you talk to a lot of commercial AI firms. They talk of their IP as their company. It is one and the same. And so this discussion of whether we give certain use rights up to the government, well, that could legitimately be an existential question for that particular business. And so there's from a customer perspective, that's challenging, because we need the use rights required for us to accomplish the mission, and also be able to know that we're getting a fair price, since we're stewards of the taxpayer dollar. That's challenging to do with trade secrets. Yet we still need this technology. And so I think from kind of my experience working with the Air Force and other agencies within DoD and IC, and certainly from kind of this very unique experience working alongside academia and FFRDC, the patents really are what we would prefer, right? Even though it is public, because it does it creates there's more innovation. We get to build on other people's hard work, and under our system, they get rewarded for that. So that's different than in other IP frameworks. And so I think that patents can still incentivize innovation. And is there a risk of that getting out? Yes, but I think that's one right now we're willing to pay. And most of you have seen a patent. If you could have it, but you have the patent, the fully public patent, and still have no idea what to do with it. It might take you years to actually figure out how to actually work it. And so we're still ahead if we are doing that, but we're able to capitalize on that IP and sharing it publicly with potential competitors, but because that still is going to advance the state of the art in machine learning.
Well, Kate, I mean, this is your area of expertise. Give us your thoughts on this. I
just want to make sure that the attendees are familiar with some of the numbers, right? So there were 600,000 patent applications filed in 2020. And many of those patent applications have many embodiments. And that's even just considering, like, if I have one invention and then, I might describe little tweaks on it, but oftentimes, an invention might have 10, 15 different parts, and each one of them might have a tweak, right? And so we've pretty much gotten rid of the best mode requirement here. So you can disclose everything. So one of them probably works really, really, really well. And so long as you can cover the umbrella, you've covered that whole space. But somebody looking at a patent, it's not like you're going to take a patent or a patent application and be able to recreate the code. There's a lot of figuring out the specifics in order to make it work in the software space. And so I just want to make sure people understand, it's not like you pick up a patent application and it tells you exactly what to type in.
Right, and you're dumping the source code online, right? Yeah. So Daryl, what about the point that both Andrew and Kate have made? I mean, how do you think this all plays out? Where's the balance there? Is disclosure a net positive, as we've always thought traditionally, or is it potentially problematic in this larger competition with China?
So, as an academic, I'll answer the academic way, which is I'll refer you to it. article that, well, not that bad.
All right.
The Mark Lemley, I think Bhavan Sampath wrote a number of years ago about the value of patent disclosure. And actually, they did an empirical study. The answer is actually confirming what Kate said, not very useful. I mean, it ticks a box. Person having ordinary skill in the art and the patent examiner's view has to be able to make and use the invention, etc. But in terms of actually being able to reproduce it, well, let's look at the real world. Before China came along, the subject of this question, there was Russia, there was the Middle East, there were a whole other host of other countries which would, if they could just pick up a patent and supersede the United States in terms of its technological prowess, would have done so many, many decades ago.
And they didn't.
And they didn't. So I think that's the first important point. The second important point, maybe one that underlies the question, is what can we do about it? As the United States, and we are out of trade agreements like the CPTPP, well, you could still focus on bits which are not so politically sensitive, like the digital economy, like the green economy, like green financing. All of these things actually use a lot of AI. And it's much more palatable, especially in this administration, to be talking about green financing, about sustainability.
Right.
So use the zeitgeist to your advantage. And of course, a final point, important piece of the puzzle, especially with you and Andy on the call, is national security. I think there is no greater deterrence than a stable, united geopolitical front with your allies. And AUKUS, I think, was a great step forward in ensuring that in the Asian theater. However, of course, you don't do it while making your ex-allies feel like jilted girlfriends. I don't think that's necessarily the best execution, but neither was Afghanistan, and I suppose you live and learn.
Well, that is, I mean, that may be the understatement of the century, but I'm with you there on that, Daryl. So Kate, question for you from Peter Gowdy. He's asking whether it's accurate to say that national security related AI patent applications may be handled in a class as classified applications. Have you heard that? Is there any sort of stuff going on around about that? And I'll come to Andrew on this in a second too. But Kate, have you heard anything like that?
Yeah, the name is escaping me right now, but there is some provision where you can have a security application. I'm sure that Andy knows this, at the tip of his tongue, but that's something that you don't have much control about. You file your patent application, and then when you get the filing receipt, the patent office either says, like, you can go file this wherever, file it in whatever country you'd like, or no. And what I've heard, I'm not in this space, although a colleague of mine is, and I've heard it's a nightmare. Like, you really then cannot disclose it. And it's also very weird because from the patent office perspective, I did a study on it. It was just too long ago for me to remember most of this. But once the patent application is allowed, and then it sits for like decades, possibly, however long the patent office does not want to print it. Because in order for it to be issued, they have to publish it, right? And so then you're compensated for it. And I forget all the provisions. Again, I'm not the person to be providing this, but I've always found it to be just like this fascinating. But it's a super small percentage of patent applications that are classified like this. And so I highly doubt that AI security patent applications, as most people on this call would be thinking of that technology, are the type that get classified in this situation. It's more of like weapons, is my understanding.
Yeah. So Andy, do you want to jump in on this? Any thoughts on, obviously without getting classified information goes without saying, any thoughts about whether this might be an issue and how it plays out, and whether there's any relevance to the AI context that we can think about?
So there are classified patent applications. There's a Invention Secrecy Act that dates back to the Cold War, and so that is a thing. Whether it has a whole lot of relevance in AI, I could say I don't personally know. But just kind of knowing how AI patents would really work, I think that the technology has to be probably more advanced than it is currently for it to really become more relevant. Not to say that there isn't, but that's kind of my understanding is The types of things that would are not the type of algorithms that we're working on, and part of that is just kind of the limitations of the state of the art right now. And so, could there be? I think usually it's kind of for. It's not the subject matter of the invention. It's kind of the application that could be classified.
Right.
And so, is it relevant? Potentially. Could it be relevant in the future with certain advancements? And if you get more close to something akin of a AGI, then yeah, I think that's when you start to see that become much more relevant.
So, Joe, might I rope you into this conversation and just see whether you have any thoughts on this question that was asked about the use of sort of the Invention Secrecy Act and these potential classified patents. But I also want to draw in on the question of incentives, right? We've always thought, as we've talked about now a couple of times, that one of the key incentives for society writ large in granting this monopoly right is disclosure. Right? Of course, the disclosure is put in abeyance by the Invention Secrecy Act and some classification of a patent. Are we getting the bang for the buck? I get that we have this national security benefit, right? But that wasn't the sort of the theory of the patent system. The theory of the patent system was monopoly right for a temporary period of time, disclosures of public additional innovation, right? How should we be thinking about this?
So this is where I'll be the academic. I'll say it depends. It depends because if you look at the tech industry, what's ultimately driving them is first mover advantage. They're not really concerned about patents as much. I don't think AI changes that. If you talk about the pharma industry, you heard this morning the panel talking about data protection, data exclusivity. These are things which for them are more valuable, or at least as valuable as patent protection when it comes to pharma drug development in general, but also in the context of AI. And I don't think the fundamentals of how those industries work is going to change tremendously, even with the introduction of AI.
Right.
And then your other question about, so are we getting the bang for the buck? Well, as consumers, do we really care? I'm not sure that we really care. I think we are just as happy as Chinese consumers when a tech product comes out that is called Astro or Alexa, and we just use it happily. But from a societal point of view, you may be more sophisticated as a business owner. And it comes back to my initial comment about, is the system broke? I think if the system were broke, you would have heard it among the 200 people, companies that responded to the USPTO. The concern was, how do we adapt to make sure that we deal with the black box issue with AI, deal with the FOSITA issue with AI, but nobody's calling and screaming and saying the sky is falling on our heads. Please save us, and we are getting a bad deal out of this. So I think it's important as observers, as practitioners, as government people, not to be in the ivory tower. It's not only academics that are at the risk of that, but really to be in Main Street and to be in Wall Street and understand what the business sentiments are, what the geopolitical sentiments are, so that we can actually have a constructive debate and not talk past each other.
Yeah, well, it strikes me that that's a great place to wrap up on this idea that we should really focus on the business and national security implications and engage in a conversation that's actually productive. So with that, thank you to Daryl, to Kate, to Andy, who I've been calling Andrew this whole time, and I realized that I should be calling Andy. Thank you all for being here. Thank you for the conversation. Thank you again to Joshua, Mary Claire, the whole team at CIP. CIP Squared for having us here and having this and creating this conversation. For those of the audience, we're stopping a couple of minutes early, but there will be a keynote chat starting at keynote fireside chat starting at 4:45, I believe. Thanks to everybody once again. And Joshua, any last comments from you before we go on a break till 4:45?
No, I think you got everything. So thanks again to Jermil and all the panelists, and we'll see everyone back in about 12 minutes to start our fireside chat, which should be very interesting.
Thanks all.